Let's begin with a brief, very broad historical overview to set the stage for the emergence of the classical school. And we'll start in Europe in the Middle Ages, the time periods ranging from roughly 500 to 1500 AD after the fall of the Roman Empire. This is when any structure previously imposed on European society fell apart, and any progress previously made in developing formal systems of law were lost. It is often referred to also as the Dark Ages because it is characterized by a lack of progress in science or culture. This period was largely dominated by feudalism, with designated noble lords holding total control over lands given to them by the crown, and anyone living in those lands was subject to their rule. Society moved from being centralized in larger cities under the Roman Empire to very decentralized and isolated in rural agricultural communities with little travel or communication among them. As a result, local laws and definitions of what constituted a crime varied quite widely across communities. It also led to a perpetual fear and suspicion of anyone deemed an outsider or who deviated from accepted social norms. Through a lens of superstition, deviant behavior was viewed as being driven by satanic possession. People accused of possession were tortured in what was known as trial by ordeal. It was considered a judgment of God, who would ultimately make the determination by performing a miracle to save or heal the innocent. Those who were severely injured or died were deemed guilty. A water trial was a bit different in that the accused were bound and thrown in the water. Floating was thought to be indicative of witchcraft, while the innocent would sink and be pulled out with a rope. A similar solution was trial by combat, which has unfortunately come up again in our national discourse recently, where two parties having a disagreement would battle it out, with whoever was left alive being declared in the right. Naturally, death was the most common penalty for crime during this period, regardless of its seriousness. As Europe moved out of the Middle Ages into the 1500s, I simply term this a transitional period for lack of a more formally recognized description, it began to be more widely recognized that the feudal system had major problems and a new approach was needed. This started particularly in England and France, who passed more structured laws governing behavior and defining crime. But the change was slow, and there was no formal policy or guidance regarding punishment for breaking the law, and crime was still seen as sinful, immoral, or a sign of mental illness. As a result, local magistrates dictated how the law was interpreted and enforced, so there was very wide variation across communities, much like with the feudal system. Guilt was not determined through a formal legal process, and punishments were largely vindictive and arbitrary. Common punishments focused on retribution, including isolation or banishment, torture and corporal punishment, and capital punishment, but also restitution in some cases. This brings us to the Age of Enlightenment, or the Age of Reason, in the 1600s and 1700s. It was part of a broader philosophical, political, and social movement that signified the move away from the domination of the monarchy and feudalism and an acknowledgement of individual liberty, reason, and agency. No longer would the idea that things are the way they are because God made them that way be as universally accepted. Instead, it was reasoned that God gave humans logic and reason and the free will to act on their own. Therefore, societal structures should be set up with the input and consent of the people to serve the interests of the people, rather than the people being forced to serve the will of the monarchy. It represented a complete turn in what people thought about how they should be governed. This is where the foundation of constitutional government, a formalized legal system, and separation between church and state really took hold. It is no coincidence that the movement toward American independence grew during this same time, and these principles that arose during the Enlightenment provided the philosophical foundation for the Declaration of Independence, the U.S. Constitution, and the U.S. legal system. The idea is that society exists for the benefit of the individual. Individuals have natural-born rights, such as life, liberty, and ownership of property. So, individuals benefit by joining society to protect these interests. This is known as the social contract, where individuals agree to cooperate with one another in a civil society for mutual benefit. We only give up those rights that are necessary to protect the rights of others in society. Laws should exist to protect these rights of individuals and society as a whole, and should be applied equally to all individuals regardless of their class or social status. With the Enlightenment came a recognition of major problems with the way crime and justice had been handled up to that point. Inconsistent and wildly out of balance laws and punishments handed down according to the whims of local magistrates. These new ways of thinking are where the classical school of criminology originated. The classical school shaped views of how the legal system should work and what constitutes a crime and the appropriate punishments for crime. There was a growing acceptance that people were responsible for their own behaviors and sense of morality. The world is organized by free will, not predetermined. And if individuals have the free will to choose their own behavior according to human nature, then crime itself, the choice to violate the law or engage in behavior that violates the rights of others in violation of the social contract, is also a part of human nature. Crimes are defined as acts committed against the social contract. Crime weakens society's ability to protect the individual, is therefore bad for the individual, and therefore must be prohibited. This philosophy of the classical school of criminology was first attributed to Italian scholar Cesare Beccaria, who published his essays on crime and punishments in the 1760s. It was first published in Italian, obviously, but quickly translated into multiple languages and widely read across Europe and America. His ideas built on the social contract to arrive at a theory of punishment and how it should be applied in a formal legal system. Laws should serve the social contract and be passed by a legislature that represents the interests of different segments of society. Laws should be clearly outlined in writing with specific definitions of prohibited behaviors and punishments for engaging in those behaviors in a way that is easy for people to understand. This way, they are in place in advance of any decision to commit a criminal act. And importantly, laws should be applied equally to all people, with the same punishments given for the same crimes. The purpose of punishment is to prevent crimes from being committed in the first place. The idea is that it is always better to prevent crime than to punish it after crime has occurred. So, punishment should center on prevention rather than retribution. Crime can be seen as the result of poor laws and punishments. The solution to crime should then be to alter the laws and punishments accordingly to better prevent crime from occurring. And because individuals who commit crime are not evil or possessed, but rather simply made poor choices, they should be treated with care and dignity. For this reason, Beccaria advocated for due process and against torture and capital punishment. He reasoned that individuals who are killed are no longer in society, and that individuals shouldn't have to give up their life to be a member of society. It's too big of a price to pay. Individuals should only give up just enough of their rights to protect the rights of others. Therefore, he argued for incarceration as a more appropriate punishment. Another prominent early scholar of classical criminology is Jeremy Bentham, who built on Beccaria's work to refine a practical theory of punishment, perhaps most prominently in his book, An Introduction to the Principles of Morals and Legislation, published 20 years after Beccaria. Like Beccaria, Bentham also believed punishment should center on prevention rather than retribution. He was guided by the philosophy of utilitarianism, the greatest happiness principle. The goal of society should be to achieve the greatest happiness for the greatest number of people. Punishment should be set up in a way that they are proportional to the crime committed, not wildly out of balance as they had been previously. The goal of punishment is to balance out the impact of the crime. It should be just slightly more severe than the crime it's punishing. Punishment that is too harsh outweighs crime it is intended to prevent. It does more harm than good by doing more harm for a greater number than it should, and society becomes unbalanced and unstable as a result. If every crime resulted in the maximum penalty regardless of its severity, this might encourage more crime because there is simply nothing stopping individuals from escalating offenses if the punishment is going to be the same regardless of what they do. These are ideas that we'll come back to later. Bentham believed individuals choose their actions after weighing the potential costs and benefits. He developed the hedonistic, or pain-pleasure calculus. Basically, the idea is that people want to have pleasure and avoid pain. So, individuals will choose actions they believe will increase their pleasure and avoid behaviors they believe will bring pain. In assessing this calculus, different values are placed on pleasures or pains depending on their intensity, duration, and certainty. And it's not just immediate pleasure or pain, but the possibility of future pleasure or pain. Therefore, individuals weigh the probability of future and present pleasure against the probability of future and present pain. Bentham also believed individuals should only be punished when they can fully assess the repercussions of their criminal actions, that it isn't right to punish those who cannot fully understand what they did and why it was wrong. If they are unable to fully engage in a hedonistic calculus, such as juveniles or the mentally ill, they shouldn't be punished in the same way. Therefore, numerous factors should be considered when determining the impact of an act on society aside from just the act itself, including intent, was it done intentionally, motive, why was it done, outcome, what happened as a result, and any mitigating circumstances surrounding the act. So, to recap, the basic elements of the classical criminological perspective are that people have the free will to choose their actions, criminal acts are attractive because they require less work for greater payoff, and the choice to engage in crime is controlled by potential punishments. People will avoid pleasurable acts, such as the benefits that may be gained from crime, if the resulting pain or fear of punishment is sufficient enough to counteract those benefits. These ideas, put forth by Beccaria and Bentham, formed the foundation for what became known as Deterrence Theory. To be effective at preventing or deterring crime, punishments must have three basic elements: severity, certainty, and swiftness. The punishment must be severe enough to balance out the impact of the crime, individuals must know the punishment is certain to come if they commit the criminal act, and the punishment must come swiftly after the crime is committed, so the two are inherently tied together. All of these elements are necessary for deterrence to work effectively in practice. But how feasible is it to get all three at the same time to achieve a deterrence effect? Keep this question in mind and we'll come back to it. There are two basic types of deterrence: specific and general. Specific deterrence applies to reoffending decisions by individual offenders, while general deterrence refers to a broader societal impact on choices of potential offenders to engage in crime. A simple illustration of the difference can be made using the death penalty. The death penalty has two intended purposes: to prevent the specific offender from committing future crimes, and to deter others in society from committing similar crimes. It certainly has a specific deterrence effect. Dead people can't commit crimes in the future. But does it have a general deterrence effect by preventing others from committing crime? That's a more open question. And keep in mind, that's just to illustrate the difference, not to speak to the overall effectiveness of any general or specific deterrence strategies, which we'll get into now. Beginning with general deterrence, laws and punishments are designed in a way to prevent crime among the general public. General deterrence is based on perceptions. If individuals are more likely to commit crime if they perceive that the benefits outweigh the risks, then the fear of criminal penalties convinces any potential law violators that the pains of punishment for committing the crime outweigh those benefits. We see others being punished for crime, so we decide it's not worth it to do it ourselves. How well does general deterrence work? Well, it certainly works to some extent. Most people don't engage in most crimes, and a common reason why is that they don't want to be punished. But this is also closely intertwined with moral and ethical decision-making. For example, is fear of being thrown in prison the only thing stopping you from walking into a bank, shooting the teller behind the counter, and walking out with the money? In other words, if you knew you would not be caught and punished, is this something that you would just go ahead and do? While some may say yes, most still would not. If I changed the previous scenario to walking in the bank and taking the money without shooting the teller, does that change your calculus? I imagine many more would go ahead and take the money than would have previously when physically harming someone was part of the equation. However, most still would not. To this point, is it the belief that these actions are inherently wrong the reason we don't do them? Is it the fear of potential punishment? Or is it concern over what our family, friends, and other peers will think of us? So it can be difficult to break apart these relative influences on our behavior. And some crimes are more deterrable than others, some offenders are more deterrable than others. It should also be noted that the goal of general deterrence does not necessarily have to be entirely eliminating a crime. Instead, it could achieve varying degrees of restrictive or partial deterrence, where the threat of punishment reduces the frequency, severity, and duration of a crime. Consider the effect of a patrol car sitting on the side of the highway to deter speeding. Does this work to eliminate speeding entirely? No, certainly not. Do people slow down when they see the patrol car? Yes, absolutely. Do most people then speed back up again as soon as they pass the patrol car? Yeah, probably. But many won't. Many will be going the speed limit or just slightly over it, at least for a while. So there is some kind of restrictive or partial deterrent effect there. How much of a general as opposed to a restrictive deterrent effect fear of punishment has depends on perception, and largely on how individuals perceive the effectiveness, fairness, and legitimacy of the law and the justice system. We'll address some of the shortcomings of many common deterrence-based approaches to crime control in a little bit. Next, there is specific deterrence, which applies to an individual after being caught for committing a crime. It is the view that criminal sanctions should be sufficiently severe that offenders will never again repeat their criminal acts. It targets both the motivation and opportunity to engage in criminal behavior. Specific deterrence certainly has some impact, but a key question is how much does it have to do with the severity of the punishment? Let's go back to the example of driving on the highway. If you get pulled over for speeding, you're likely to drive closer to the speed limit, at least for a while. But what if you receive a speeding ticket? Are you less likely to speed if you're given that ticket? What if you were arrested for speeding? Are you less likely to speed then? Probably. You're also probably going to be pretty angry and resentful too. But what if merely being pulled over were enough to deter you from speeding? If being pulled over is sufficient to change your behavior, do the ticket or arrest make sense as strategies for specific deterrence? Or are they overkill and potentially counterproductive? Like with general deterrence, the key elements of specific deterrence are not as straightforward to tease out as it may initially appear. In application, specific deterrence has been applied primarily to the severity of the punishment, namely how long offenders are incarcerated, and specifically chronic or repeat offenders. Individuals who are locked up cannot commit crime, at least against the general public. The incapacitation effect is the idea that keeping these offenders locked up for longer periods of time eliminates the risk of them committing future offenses. This has been the primary philosophy governing punishment in the U.S. since the 1970s, and as a result, more people are locked up here as a portion of the population than anywhere else in the world. Accordingly, we would expect the crime rate would decrease as the incarceration rate increased. But this hasn't always worked out in practice. There have indeed been periods of time where incarceration rates increased while overall crime was decreasing. Other times, though, increasing incarceration rates coincided with increasing crime rates. So, it's an inconsistent relationship. It may also be that instead of deterring crime, harsher punishments like lengthy sentences may merely delay or actually increase crime. Why might this occur? Well, there are numerous possible reasons. If a person is locked up for a long time, who are they locked up with? Other criminals, many of whom are more experienced, chronic, severe offenders. They come to empathize with and learn from them, including defiant and resentful attitudes toward the justice system and society in general. Their associations with like-minded criminals, harsh environment, and the stigma of harsh punishment may lead them to adopt a criminal identity. Incarceration may exacerbate pre-existing problems or create new ones, including psychological problems. The emphasis on incarceration has other costs. It's enormously expensive. It costs anywhere between $15,000 and $80,000 to keep one person in prison for a year, depending on the state. And it has led to major overcrowding and poor conditions. It has tremendous negative impacts on families and communities. And in neighborhoods where a large number of people have a criminal record, any specific deterrence effect will be negligible because it loses its potential impact on future behavior. So all of these are potential factors undermining lengthy periods of incarceration as a specific deterrence strategy. This points to something about deterrence that is commonly overlooked or misunderstood. By far, the element of deterrence that receives the most attention is severity. When talking about how to reduce crime, the go-to solution is increase the punishment. Instead of 10 years, make it 20 years. Range of possible punishments? No, take those away. Make it a mandatory minimum sentence. If people know how severe the punishment is, they won't commit the crime, right? Problem solved. Well, not exactly. This ignores the other two elements of deterrence. Ask yourself this question. What difference does a potential 20-year sentence, as opposed to 5 or 10 years, make to someone who does not believe they will ever be caught? On the other hand, if there was a near certainty of being caught, would you trade the crime for 10 years in prison? How about 5? Or even 1? This certainty is key to deterring criminal behavior, but is sorely lacking and receives far less attention than severity. What would it take to increase the certainty of punishment? Swiftness is also critical, but no less problematic. To have a deterrent effect, the punishment should be issued quickly and closely following the commission of the crime. This is inherently difficult in most criminal cases. Thorough investigations and court proceedings ensuring due process take time, but are essential to ensuring the right people are charged with crimes committed and that people are treated fairly, that their rights are upheld. At the same time, though, the timing of the punishment moves further and further away from the crime, putting a distance between them and diluting any deterrent effect the punishment may have. And that's where we're going to leave it for this video. Next week we'll focus on how the classical school informs theories centered around opportunities to commit crime. Specifically, we'll look at rational choice theory, routine activities theory, and situational crime prevention. Have a good one.